Okay, I think we have come to a resolution. Ms. O'Connell.
Thank you, Chair. And in effort to speed this along, I'm going to withdraw my amendment.
Okay, we need unanimous consent. Do we have unanimous consent? Yes, okay, go ahead. Mr. McGregor.
And I'm going to ask for two unanimous consents. The first unanimous consent is I ask to withdraw my amendment.
Unanimous consent? Yes, okay.
And my second ask for unanimous consent is that we amend, I think it is it line 16? I'm just looking at the clerks I'm making sure I've got it correct. Line 16 on page 76.
I'm going to need a copy of that. Could you email it? Do you have any?
Well, we've got it all kind of spelled out here.
Okay,
I'm just going to basically read out the sub-amendment and amendment together.
Well, we'll try that and see how far we go, okay? Go ahead.
Okay, so replacing lines 16 and 17 with B, provincial, comma, territorial, comma, or municipal, political, or governmental processes.
Territorial, comma, or? Okay.
Provincial, comma, territorial, comma, or municipal or governmental processes. I'll just need them to repeat that.
We're good?
If you could just repeat that again.
Could you repeat that one more time?
Certainly. So replacing line 16 and 17 on page 76 with the following: B, provincial, comma, territorial, comma, or municipal, political, or governmental processes.
Okay. I think we're clear on that. Yes? Do we have unanimous consent to take this action? Yes, we do. Over the ruling of the chair and all. Okay. Let us carry forward. So I think what this means is that NDP 7 and BQ 13, as we said before, can't be moved, I believe, right? If NDP 6 was moved, then NDP 7 and BQ 3 could not be moved because they were identical. They're no longer identical, so I'm not sure whether.
That's right. That's right. So they can no
longer be moved because of conflict now, right?
Yeah.
Okay. All right. So they can no longer be moved. So that brings us to BQ4. Monsieur Vermeulen, s'il vous plaît.
Mr. Chair, I'm pleased to move BQ4, the purpose of which is to add Crown corporations and universities as suggested by Mr. Fadden, the former CSIS director, and Ms. Long. I've forgotten the name of the diaspora. It was Hong Kong Link or something of the kind. The intention was to ensure that the Act would apply to those institutions because they are places where foreign interference occurs currently.
Okay, is there any discussion? Mr. Gayer.
Thank you, Chair. We think this might be an overcorrection beyond what the position of the government, but I'd like to ask the officials on their position.
Thank you, Chair, for that question. The proposed amendment in relation to D, the political or governmental process of federal or provincial Crown corporation, the intent and interpretation is that the current definitions in the Act, in Bill C-70, include Crown corporations, and so our interpretation, obviously, which would be subject to the Commissioner's interpretation, is that those are already included in the definition. In terms of political or governmental processes of a university or government research center, I would say that the proposed amendment goes beyond what we intended in terms of the transparency registry. It was intended to go out to increase transparency in activities related to government and political processes, whether it be the federal, provincial, or territorial or indigenous government, and would go far beyond that. I would say that in terms of research, in terms of the universities, again, it would significantly expand the scope, and I would say that there's already a number of initiatives that are in place in programs such as the Safeguard and Science Initiative, the outreach program at the service, and new national security guidelines for research partnerships that are aimed at tackling the problem of research security. And the transparency proposals here as they relate to the government would be more difficult and very difficult to apply in the context of a university, because it would target the government and political process of the university, which is very different than the government or political process of a government.
Oui, Monsieur le Président, pour ma...
Well, Mr. Chair, overall, Bill C-70 that we're considering is attempting to fix a problem. And that problem, well, it's difficult in terms of enforcement in some cases, but the fact remains that universities that receive federal funds are currently the target of foreign interference, despite the programs that Mr. Bilodeau listed. So if the intention of the bill is that one needs to be more transparent in order to reduce or eliminate foreign interference, well, it's a tad ambitious, but the fact remains that if we want to reduce the harms of foreign interference, well, one cannot escape the fact that the universities are being targeted.
Thank you, sir. Any other discussion? Shall BQ4 carry? No. Negative. Okay. That brings us to BQ5. Monsieur Villemure.
Thank you, Mr. Chairperson. I'm pleased to move BQ5. And I'll be concise. It's the double registration amendment that we discussed a couple of months back. You know, Mr. Chair, it's perhaps not conventional, and I understand that. But when you want to establish a link between both parties, it's wise to identify the two parties in question in the first place. Now, I know that for some orders, the measures won't be the same. For example, at a university, it might be different, but when it comes to a public office holder, the individual who would be on the registry as a foreign principal, well, that's the link that we're trying to establish to determine the legitimacy or otherwise of the relationship. Now, I don't know who the other party would be, but it's difficult to make that link with the foreign principal otherwise. So here's what I'd say right off the bat. It's been told to us in the committee, good idea, bad idea, on the fence, a lot of different opinions. But it's not one of the best practices per se to have having a double enrollment or registration is a guarantee of being able to identify a source in a more certain manner.
To interrupt you after you moved, so that I have to make a ruling on this. So Bill C-70 amends several acts and enacts the Foreign Influence Transparency and Accountability Act. The bill provides that persons who enter into an arrangement with a foreign principal under which they undertake to carry out certain activities are required to provide the Commissioner with the information specified in the regulations. The amendment seeks to add that even if no arrangement has been entered into, any individual other than a public office holder must file a return with the Commissioner if that individual receives a communication from a foreign principal requesting that the individual take certain actions. In the opinion of the Chair, the amendment adds a new concept that is beyond the scope of the bill as adopted by the House at second reading. Therefore, I rule the amendment inadmissible. Go ahead, Mr.
Well, respectfully, I'd like to challenge your decision, Mr. Chair. Absolutely.
The question is, shall the decision of the chair be sustained? I think that was on division. Shall we have a recorded vote? Yes, please.
Mr. Biddle.
Yes.
Mr. Gahir.
Yes.
Mr. McDonald. Ms. O'Connell.
Yes.
Ms. Zaid.
Yes.
Mr. Caputo.
Yes.
Mr. Chong.
Yes.
Mr. Shipley.
Yes.
Monsieur Villemur.
No.
Mr. McGregor.
No.
Oh, Mr. Motz. Sorry.
Yes.
Very sorry. Mr. McGregor. Six yeas, 4 nays.
Okay, decision is sustained. That brings us to BQ. Sorry, that was
That was BQ5.
That was BQ5. So that brings us to BQ6. So if you, Monsieur Villemur, if you move it, but I also have to rule on this one as well. So.
Wait.
So Bill C-70 amends several acts and so on and so forth. Once again, the amendment creates a new concept that is beyond the scope of the bill as adopted by the House at second reading. Therefore, I rule the amendment inadmissible. Monsieur?
I'd like to challenge your decision, Mr. Chair.
Shall the decision of the chair be sustained? Do we need a recorded division? Oui?
Mr. Biddle. Yes. Mr. Gahir.
Yes.
Mr. McDonald. Ms. O'Connell.
Yes.
Ms. Zaid.
Yes.
Mr. Caputo.
Yes.
Mr. Chong.
Yes.
Mr. Motz.
Yes.
Mr. Shipley.
Yes.
Monsieur Villemur.
No.
Mr. McGregor.
Thank you.
So, 9 yeas, 2 nays.
Merci. That brings us to BQ7. Mr. Villemur, would you like to move this? And also,
No.
No? You're not? Okay. That brings us to BQ8. Did you wish, Mr. Villemur? I will also have to.
Wait.
So, did you wish to move BQ8? Yes? Yes. So same problem. In the opinion of the chair, the amendment creates a new concept that is beyond the scope of the bill as adopted by the House at second reading. Therefore, I rule the amendment inadmissible. Challenge? Absolument. Let's do a recorded division, please. Shall the decision of the chair be sustained?
Mr. Biddle.
Yes.
Mr. Gahir.
Yes.
Mr. McDonald. Ms. O'Connell.
Yes.
Ms. Zahid.
Yes.
Mr. Caputo.
Yes.
Mr. Chong.
Yes.
Mr. Motz.
Yes.
Mr. Shipley.
Yes.
Monsieur Villemur. Mr. McGregor.
No.
9 yeas, 2 nays.
Merci. That brings us to BQ9, which I'll give you forewarning. I'm not going to rule inadmissible.
Merci, Monsieur le Président.
Yeah. To rule on it until it's moved. It's kind of a gotcha, really. But anyway, go ahead.
Je vais présenter le BQ.
I'll present BQ9 if I may, Mr. Chairperson, at this stage. Absolutely. Several witnesses, including Dr. Chalbert, Mr. Junot Cassier, and Mr. Fadden, told us that it was wise, in fact indispensable, that public office holders benefit or be subject to a cooling off period for a 3-year period. Now, the purpose is to prevent former office holders to enter into arrangements with foreign principles. The goal is clear, and we want to ensure that newly elected members can benefit from this as well. We think it's a very wise amendment that's in line with the public interest, and that is why we've moved BQ9, and it's up for debate.
Thank you, Mr. Villemure. Ms. O'Connell, please.
Thank you, Chair. Well, I think the intentions are good in the sense that if there was a foreign state trying to influence Canada and then a former public office holder went to go work with them, that would be problematic. The problem is this amendment is quite broad, and it just says a former public office holder cannot enter into an agreement with a foreign principal. What if that arrangement was something with one of our allies, with, promoting democracy or doing work that I think many public office holders and the experience in Canada would be actually quite helpful. So there's a distinction between a foreign agent or influence type work, and then a difference between doing also important work that promotes actually democracy around the world, and this does not distinguish the two. The other concern I have is it's just too broad and doesn't deal with it. And should an individual, whether they are a public office holder or not, become or enter into an arrangement with a foreign principal that is to impact or advise on behalf of that foreign principal, they'd be subject to the foreign agent registry and would have to be identified on that anyway. So I feel like that transparency piece deals with, again, I think the intentions are good. It's just the drafting of it, I think, is too broad to allow for the distinction, and I think the registry itself would then allow for the disclosure of that individual and any sort of foreign principal arrangements. So we can't support it as drafted.
Thank you. Mr. McGregor, go ahead.
I think this is a solid amendment. I won't go over the reasons Mr. Villemure said, but the NCCOP report that was tabled last week did talk about how some public office holders are expecting a quid pro quo arrangement, and I think if we're going to nip that problem in the bud by putting it in the law that a public office holder cannot enter into an arrangement with a foreign principal for this specified period of 3 years, that's a good proactive step here. It shows foreign principals that your investments are not going to bear any fruit. Mm-hmm. So again, we have to look at the seriousness of the problem, and I believe it is incumbent upon this committee to explore all of the legislative options at our disposal. So I will be happily supporting this amendment.
Thank you, Mr. McGregor. Is there any further discussion?
Sure.
Mr. McDonald.
Can we ask the officials if there's any consequences or complications in adopting this as is?
Thank you. I think one of the things that when we looked at the amendment that stood out is there are other already provisions in the Conflict of Interest Act, and so we would have to explore the consequences of this or the interactions between a prohibition and the conflict of interest legislation. There are also questions about whether the registry, by requiring the transparency, is sufficient to shine a light, which is what the transparency registry is about, right? It is about increasing transparency of that influence in Canada. And so those are the two things that I would point out, but definitely the interaction between this and existing legislation, whether it's a lobbying act or the Conflict of Interest Act, would be worth exploring.
Mr. Villemure.
Thank you for the clarification. I think that the very nature of the threat that we're discussing today warrants the fact that, or justifies the fact that, yes, it will be complex, yes, it will be difficult, and yes, we have to go ahead with it nevertheless. These are not unprecedented cases that are being referred to. As my colleague from the NDP said, we're talking about foreign powers that are currently investing in people in order to do X, Y, and Z. And it strikes me that the threat level of the threat itself, speaks for itself. And are we going to leave some wiggle room for interpretation? Yes, to some extent, but having legislation that in this manner is not a good idea.
Any further discussion? Shall BQ9 carry? BQ9 does not carry. That brings us to NDP 8. Mr. McGregor, please.
Thank you, Chair. I'm just going to get to the correct page here. Yes. So this was an amendment drafted by my colleague, Ms. Kwan, and her notes here were just referring to the fact that the China Strategic Risks Institute says that the new act being created in Part 4 does not provide the relevant authorities with a mechanism to notify affected parties of a registration requirement, nor to warn the public about foreign agents of concern. Such proactive mechanisms could be developed, modeled on the information notices and transparency notices within the Australian model. And that's essentially what this new 8.1 is designed to do. So I will leave it at that.
Thank you. Any discussion? Ms. O'Connell.
Thank you. When I first read this, I had some concerns about the automatic kind of listing of relatives, and relatives are loosely designed or defined, and acquaintances. And given some of the foreign interference that has happened, there could be unintended consequences of an individual having nothing to do with any attempts of foreign influence, but their relative would then be kind of list them, so to speak. That was my initial concern, but perhaps I'll turn to officials to for one, is that kind of reaction how you would read it? And two, do you have other concerns in regards to that connection? I know Mr. McGregor mentioned the Australian model, but there are differences, and I think it's around the defining of some of this. And so, again, I just have some concerns, especially when we heard testimony about individuals being intimidated, and I think it's not the intention of the bill to then pre-associate relatives just by nature of being related to another individual. Could I maybe have some clarification? Thank you.
Thank you, and thank you for the question. So we did note, Chair, the connection to the Australian model. We would just say that the difference in the Australian model is that foreign government-related entity and foreign government-related individual is defined in the Australian model, where it is not currently in the definition in the proposed act. The definition of foreign principal is specific to foreign state, foreign power, foreign entity, and foreign economic entity. This would provide a lot of discretion to the commissioner to apply what they consider to be related to in terms of the extent of that relationship in the application. And then I think too, the intent of the powers being afforded to the commissioner in the proposed act, it would also allow for the issuance of notices, so already without specifying the related provision.
Thank you for that. But is my understanding correct that the notices could be automatically applied to a relative? And again, the definition of relative, it could be a cousin, for all we know, could automatically be given? Because that raises all kinds of fairness questions.
Absolutely. I think that it is possible that a commissioner could interpret this very broadly and apply the designation to For example, persons related by blood, friends, acquaintances, individuals who fall within the definition of foreign principal, beyond what falls within the definition of foreign principal. And the intent of the act is certainly to work towards transparency around protecting individuals who may be most subject to that level of influence.
Thank you.
Thank you. Is there any further discussion? Seeing none, shall NDP 8 carry? No. This brings us to NDP 9, and I will have to rule on this afterwards. Mr. McGregor, if you wish to move the motion.
Thank you, Chair. And I know there were some discussions with colleagues, so I am expecting a sub-amendment. But before we get to that stage, I'll just say quickly that we did hear from a variety of witnesses who expressed a desire to see the appointment of the commissioner to be a little bit more detached from relying too much on the governor and council. And so essentially, this is providing a process for it's the same process as would be in place for the appointment of the Auditor General. And I would note that there's some remarkable similarity with CPC 3 right behind it. So I'll leave it at that and see what my colleagues have to say.
So the bill provides for the appointment by the Governor and Council of a Foreign Influence Transparency Commissioner. This amendment provides that the Governor and Council cannot make the appointment without the approval of Parliament. In the opinion of the Chair, the amendment creates a new concept that is beyond the scope of the bill as adopted by the House at second reading. Therefore, I rule the amendment inadmissible. Mr. McGregor.
I wish to challenge the Chair on that.
Absolutely. Shall the decision of the Chair be sustained? I think we need a recorded division.
Mis-
Okay,
I'm sorry?
go ahead. You were in the middle of a vote. I can't do
Yeah.
anything now.
Shall the decision of the Chair be sustained?
Mr. Biddle.
Yes.
Mr. Gahir.
Yes.
Mr. McDonald. Ms. O'Connell.
Yes.
Ms. Zahid.
Yes.
Mr. Caputo.
No.
Mr. Chong.
No.
Mr. Motz.
No.
Mr. Shipley.
No.
Monsieur Villemur.
No.
Mr. McGregor.
No.
Five yeas, 6 nays.
So the Chair is overruled.
Chair, I ask we suspend
So-
for,
Okay,
can I ask for a suspension, Mr. Chair?
Yeah, I'll just mention that, so if NDP 9 is adopted, CPC 3, BQ 10, and BQ 11 cannot be moved due to a line of conflict.
Sorry, Chair, would you be ruling CPC 9 out of order as well? Or 3, sorry, CPC 3?
Yes, I would,
Okay, can we
if it had been
suspend,
moved.
please?
But anyway, we've been asked for a suspension. Do we still need that? Okay. We are once again resumed. It's an interesting process we've got going here. Anyway, I will recognize Mr. Chung for a sub-amendment on NDP 9.
Thank you, Mr. Chair. I am moving the following sub-amendment after discussions with members from all the recognized parties on this committee. I move that we strike the words "by commission under the Great Seal" and the words contained in G by replacing line 22 on page 78 with the following: on address of the Senate and House of Commons.
Okay.
If we could just have a moment to see how it affects the bill, just to
So let's pause briefly and let legislative analysts see how it affects the bill, and then they'll advise. And we go once again to Mr. Chung.
Thank you, Mr. Chair. After consultations with the procedural clerks, the legislative clerks, I've been advised to seek unanimous consent to withdraw my sub-amendment and re-present the amendment, which has the sub-amendment in a different form that would have the same effect of the sub-amendment that I propose to withdraw.
So let's first withdraw the sub-amendment. Do you have unanimous consent to withdraw Mr. Chung's sub-amendment?
Yes.
Yes.
Okay, Mr. Chair, I propose the following sub-amendment, that the following be words be struck from the amendment. 9.1. The Governor and Council is to appoint by commission under the Great Seal an individual. And G, by replacing line 22 on page 78 with the following on address of the Senate and House of Commons.
Good. Okay, thank you. Is there any further discussion on Mr. Chong's sub-amendment? Ms. O'Connell?
Sorry, I just want to get clarification. If all of 9.1 is removed, then it would mean that it's not a governor and council appointment?
Mr. Chair, I can clarify that. That is not correct. The existing bill in front of us on page 78, on line 4, the language would remain the same, which reads as follows. 9.1, the Governor and Council is to appoint an individual to be known as the Foreign Influence Transparency Commissioner to be responsible for the administration and enforcement of this act. So that would remain as it is, unamended.
Okay. And it's just the amendment here we're dealing with then that is being changed. Okay, thank you.
We're good? Okay. Any further discussion? Shall the sub-amendment carry? Sub-amendment carries. That brings us back to the amendment as sub-amended. Is there any discussion on the amendment as amended? None? So shall NDP 9 as amended carry? Done. So that would leave CP3 up.
And BQ 10 and BQ 11.
So CPC 3 cannot be moved, and BQ
BQ 10 neither.
BQ 10 cannot move, and BQ 11 can, right?
BQ 11 can be moved now that.
Okay.
it's taken out.
This brings us to BQ 11. Monsieur Villemur, allez-y.
PQ 12, Monsieur le Président.
BQ 12, Mr. Chair, you're mistaken, I believe.
PQ 11, je m'excuse, Monsieur le Président.
Oh, sorry, no, BQ 11, you're right. It's about the Commissioner's revocation. We'd like to make an addition such that the Senate and House of Commons be part and parcel of the revocation process. If you read the amendment, and sorry, I'm just putting my finger on it, it will amend C70, 13, page 22, 78, on the address of the Senate and the House of Commons. So essentially we're adding the Senate and the House of Commons.
Sorry, I was focused on something else here. Would you say that again,
Sans
please?
problème.
No worries. So we'd like to make an addition, 2178, which would read as follows. The Governor in Council at the address of the Senate and House of Commons. It's an addition in terms of we're adding the Senate and the House of Commons.
So debate, there can be debate on that.
Yeah. Is there any discussion? Mr. McGregor?
Yeah, so I'm just curious, when it says at any time on address of the Senate and House of Commons, I'm not sure of the word address there in the English part. Is it at any time on the recommendation of the Senate? Like, it's confusing to me. Can you explain?
I think that's legal talk. Mr. Chong?
Yes, I can clarify what that means. That would mean that in order for the commissioner to be removed, they would have to be removed after an address, on address of the Senate and House of Commons, which means that a resolution of the House of Commons and a resolution of the Senate would have to be adopted in order for that person to be, for the commissioner to be removed from office.
Very well. Any further discussion? Seeing none, shall
BQ 11.
BQ 11 Carrie? No.
I hope that was the right interpretation. Sorry, it was my inside voice.
Okay,
We're now on NBQ 10.
so BQ 12 can't do it?
It can't be moved because BQ 8 wasn't
Okay.
adopted.
Arrived at NDP 10. Mr. McGregor.
Yeah, thank you. So this is an amendment to remove the administrative monetary penalties from the bill. So deleting from line, hold on, let me get the page right here. Deleting from line 22 on page 81 to line 19 on the following page, or sorry, no, to line 19 on page 83. And the reason for this is Ms. Kwan believes that there were some foreign interference activities in relation to her 2019 campaign. She did file complaints with law enforcement. And I think the outcome of that was that Elections Canada decided not to fully investigate and instead opted for an administrative penalty of, I think, $500. So she's not really interested in administrative penalties being assessed for what I think we can all agree is quite serious. And so it's removing the administrative penalties but keeping the more serious punishments in place.
Mr. Gahir.
Thank you, Chair. So, this amendment would reduce the tools that are at the disposal of the Commissioner to administer under the proposed Act. As it's currently written, the Act has 3 levels of scalable enforcement mechanisms, from issuing notices to levying fines, and then finally referring the case to law enforcement authorities. And removing this would remove that middle step, and it would be issuing notices all the way to criminal prosecutions, and there's no intermediate step in between. But I'd like to hear what the officials have to say on this step as well.
Thank you, Chair. The bill was put forward in a way that the Commissioner would have the maximum discretion on which tools to use to address specific instances of non-compliance. And there's a recognition that not all non-compliance deserves criminal punishment, but also a lot of non-compliance doesn't deserve just a notice. And having administrative monetary penalties gives that intermediate step, but it also issuing administrative monetary penalties, by their definition, are meant to encourage compliance and deter non-compliance, and so they're an important tool in doing that. And in any given situation, if the Commissioner believes in their discretion that a particular breach of the law requires more severe consequences, the Commissioner can refer the matter to a police of jurisdiction for investigation, who could then move forward with criminal charges if they deemed that appropriate.
Any further discussion? Seeing none, shall NDP 10 carry? NDP 10 negatives. Okay. BQ 13 can't be moved because other things didn't get moved. We come to NDP 11. Mr. McGregor once again.
Thank you, Chair. So we're now going to page 85. And NDP 11 is going to replace line 2 on page 85 with what you can see there, and then by adding after line 20 on the same page what you can see there. And I just want to make sure I've got it all. Yeah. So this amendment provides for the naming of foreign principals without broadly specifying a list of countries. It can be a tool that's used sparingly, an enhanced tier that allows the option of requiring increased reporting and disclosure requirements, where a mere registration is not enough to mitigate negative risks of foreign influence from hostile states. If it's used appropriately, the enhanced tier could overcome some of the problems encountered by Australia's country agnostic version. For example, the Australian Strategic Policy Institute has pointed out that the activities of the United Front Work Department of the Chinese Communist Party is entirely missing from the FITS registry, as well as the role played by the Confucius Institutes at Australian universities. So I think, overall we're respecting country agnostic registry, but just providing, a specific tier.
Discussion? No discussion?
I have a question.
Mr. Chong.
I'd like to hear from officials whether or not the activities of the United Front Work Department would be captured by Part 4 of this bill.
Thank you for the question, Chair, and I'll answer it this way. There are 3 triggers to require a registration obligation in the legislation. And so we have an arrangement, we have the 3 activities, whether they're communication with the public office holder, communication to the public, as well as disbursement of money to influence or in relation to a government or political process. Whether it's done by somebody that's operating under the United Front Work Department or some other organization, as long as those 3 elements are there, the registration obligation is triggered.
Mr. McGregor?
Just maybe to the officials, the part that we have here in this amendment where we're adding after line 20, where the governor and council may, so it's giving them the option, the cabinet the option, place the name of a foreign principal if there's a concern that that foreign principal is of particular concern. We certainly have seen, like, I believe there was a diplomat from the Chinese embassy who was named persona non grata. His name was shared all over the media. Are there any, I guess what could be some of the consequences of doing this if there is a principal who is of concern? Is there not some benefit to naming that person that's, this person is a threat?
Thank you for that question, Chair. The commissioner will have discretion in applying the legislation and determining in any given situation if the person, an entity in Canada who's in an arrangement with a foreign body, if that person meets the definition of a foreign principal. And therefore the commissioner is well placed to make that, will be well placed to make that determination. And in addition to that, I would say that the commissioner will have at their disposal the ability to issue interpretations or bulletins and could communicate information via that way as well, and would completely retain the independence to do that in any given situation.
Any further discussion? Shall NDP 11 carry? No. So BQ 14 and BQ 15 can be moved because other things were not. That brings us to BQ 16. Monsieur Villemure, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Just let me put my finger on the right page here. The purpose of this amendment has to do with the annual report, and that the Commissioner's annual report has to be submitted before the House of Commons and the Senate, rather than the Minister, to ensure greater transparency. It's one of the recommendations made by a number of witnesses, including Mr. Thomas Junot, who categorized the amendment as good practice. From a practical standpoint, on page 95 of clause 103, well, rather that in clause 113 be amended by replacing lines 22 to 28 on page 85 with the following quote: to the